Last month, Coinbase, the largest U.S. cryptocurrency exchange, said that the United States Securities and Exchange Commission had threatened to sue it over a product that Coinbase was proposing to offer to its customers called Lend. Now, this Lend product basically would have allowed customers who had deposits at Coinbase, in their account at Coinbase, to earn interest on a certain cryptocurrency that they had deposited. But the SEC said that this product would actually be an illegal security. And a lot of other companies who are offering similar products to their customers are wondering what this means for them and whether the SEC could be bringing additional enforcement actions against similar products that are offered to U.S. residents. So today I want to talk a little bit about the SEC's position with respect to Lend and how that position may be applied to some other companies that are operating within the United States. Coinbase's proposed Lend product basically would have allowed certain of its customers to earn interest on their deposits. And this product was going to be offered to the customers that hold a particular digital asset called a USD coin. The USD coin is just one stable coin. And currently, if you have an account at Coinbase, they'll hold your USD coin for you, but they won't go out and invest it, and they won't pay you interest on it. They just hold it for you. What they were going to make available through the new Lend product was a program through which, if you had USD coin on deposit, you would authorize Coinbase to go out and invest it or lend it, and in turn, Coinbase would pay interest to you. So you might get paid 4% interest on your USD coin, and Coinbase would go out and try to perhaps lend that USD coin at a higher rate of interest. That way, Coinbase makes a profit, the account holders make a profit, everybody's better off. So that probably sounds great, but the SEC didn't think so. In order to understand why the SEC thought that the Lend product was an illegal security, you first have to kind of step back and look at how U.S. courts evaluate whether or not a financial arrangement constitutes a security. So the first thing that a court does is go back and look at this law. It was written around 90 years ago called the Securities Act. And the Securities Act has a list of different examples of securities. Two items on that list are something called an investment contract and something called a note. And if a financial arrangement is either an investment contract or a note, it's a security. But the Act doesn't actually define those terms. But over time, courts have interpreted them and come up with some types of definitions, albeit a little vague. So with respect to an investment contract, a financial arrangement is an investment contract if it's an investment of money in a common enterprise with a reasonable expectation of profits due to the efforts of others. With respect to a note, courts apply an even more vague test, which is a familial resemblance test. Basically, does this financial arrangement look like what we think of as a traditional note? Neither the SEC nor Coinbase have come out and explained fully their position as to why the Lend product is a security or is not a security. But that doesn't stop us from speculating. And basically, it's likely that the SEC would look at the Lend product and say, what's basically happening here is a bunch of different depositors are all going to jointly make deposits into Coinbase accounts. That money is then going to be pooled, and Coinbase is then going to put it to good use. And the result of that will be all of these different depositors will benefit by receiving interest payments. And so that looks a lot like it is a common enterprise where there's an expectation of profits in the form of these interest payments. And those profits are going to be due to the efforts of Coinbase when Coinbase goes out and makes loans. But Coinbase, on the other hand, is likely to say, not so fast, SEC. Yes, it's true that there are going to be profits earned, but those profits aren't due to our efforts. In fact, if we as Coinbase go out and we make a bunch of loans using the deposits and those fail horribly, and we end up not making any profit whatsoever beyond what we're required to pay to the depositors, they still earn 4%. If we lend the money out and we lose money, well, we're then going to pay out of our pocket. If we make a lot of money, we keep those excess profits. But the ability of the depositors to benefit isn't due to our efforts. And they may also argue that this really isn't a common enterprise. In fact, there's a number of different individual agreements with depositors, and the ability of those depositors to profit is based on their direct relationship with Coinbase, not due to any pooling with other depositors. Now, with respect to the familiar resemblance test, the SEC is likely to say, this looks exactly like a note. A note generally is a situation in which somebody gives money to somebody else, and they're required to be repaid, and on top of that repayment, they are repaid some fixed amount or some amount of interest at the end of the year. That's one of the most typical kinds of notes. This looks exactly like that. Obviously, it's a note. Now, Coinbase is likely to say, not so fast, SEC. Yes, it does look superficially like a note, and it has certain resemblance, but, and I'm not going to get into all the details here, there's a lot of other cases where things that have looked somewhat similar to notes, or even more similar to notes, were not found to be notes. And so Coinbase is likely to say, we're more like all these other examples of cases where financial arrangements that involve a payment of interest was not found to be a traditional note. At this point, we don't know exactly what arguments Coinbase would make. We don't know exactly what legal arguments the SEC would make. And we certainly don't know what position a U.S. court would take if it were presented with these arguments. But there are a number of lessons that we can take already from the fact that this dispute occurred. And one is that it's important for any cryptocurrency company that is offering something that looks at all like a regulated financial product to consider whether or not it could be considered a security. And already a lot of companies evaluate whether or not what they're offering could constitute an investment contract, but they don't necessarily focus on whether it could be a note. So an important thing for any company to do if they're offering this type of product, and certainly if they're offering a product that repays the principal plus some amount of interest or plus some fixed payment, is whether or not it's a note. But more generally, it's important when you're going to offer this type of product to consult with counsel before you actually go out and offer the product. Because it's often the case that minor adjustments could be made in how the product works that will dramatically strengthen the argument that it is not an investment contract or that it is not a note. But if you don't consult with counsel until after you get that call from the SEC or another enforcement agency, there's not much you can do. You've already put the product out into the marketplace, and if it was unlawful, you already broke the law. So this might seem a little intimidating, but good news, I'm a lawyer. So if you'd like to discuss whether or not a financial product that you intend to offer could be unlawful under the securities laws, give me a call. I'd be happy to talk to you.